On that, I'm sorry to interrupt, but you keep mentioning irreconcilable conflict. And I think Ms. Ratner might respond, well, my duty is to show a clear abrogation of sovereign immunity, not that there's some way to reconcile these two statutes. That only comes in when we get to implied repeals under our case law, Carcieri versus Salazar. And we're not dealing with, she would say, an implied repeal here. We're dealing with an express repeal. And she has evidence, and you may find that insufficient or adequate, but and we can have that argument. But I think what she would resist your suggestion that she has to show a super clear abrogation, not only show that Congress abrogated sovereign immunity, but that it also made clear its intention to displace the FSIA. Thoughts?
Well, there are two statutes, so they have to make clear. You have to reconcile the two statutes.
Well, not necessarily. Carcieri says you have to reconcile them when one's an implied repeal. And
right.
Again, I think her argument would be, I'm not arguing about, well, she would say that too, of course, because she wouldn't give up anything. Fair enough. But I think she'd say, my primary argument is that there's an express repeal. And so, yes, in other circumstances, you go to the FSIA. But here, why couldn't Congress, for example, I mean, I think we've talked about it in Title III, if it had said we abrogate sovereign immunity, nobody would be talking about trying to reconcile that with the FSIA, right? We just
Correct.
Wouldn't be doing that. We would be taking the statute on its own terms. And she's saying that's essentially what happened here. Now, you may disagree with that, but this reconciling of things really is kind of a sideshow, isn't it?
You're right that I disagree with it. There is undisputably no express repeal.
Oh, fair enough.
Undisputably.
But you'd agree with me, though, that if it were an express repeal,
if there were an express
be talking
repeal,
about reconciling things.
Correct.
Okay.
Correct. If
all
there
right.
was, and what Kurt said about an express repeal is if the statute said in so many words that it was stripping sovereign immunity.
And that's the real question before us, isn't it?
But that's not here.
Okay. No, I understand that point.
If that's the real question, we win undeniably.
Well,
there is no express appeal that anybody could read.
I think it would probably be deniable by Ms. Ratner, at least.
Okay, yes, I'll agree with that.
And by the U.S. government, it
and
turns
maybe
out
the
too.
U.S. government.
Yeah, so,
but hopefully none of
well,
the
right,
justices.
exactly. Let's talk about that, though. And I understand the toggling on and off switch by the president can cut both ways. But one way in which it could cut against you potentially is why would Congress have put that in there except for if it thought that the FSIA didn't apply and it was kind of reverting to the old world in which courts would ask the State Department whether or not a suit should proceed as a matter of comedy and grace?
One, it's not. They didn't put it in there because they thought the FSIA applied. This statute, Title III, violated international law, extended U.S. jurisdiction in many controversial ways, and the President, Secretary of State Warren Christopher, said the statute in general, Title III in general, should not be enacted because of the very cases that you saw, the very case you saw this morning. But again, they could sue if the Foreign Sovereign Immunities Act doesn't apply. They can sue Russian airlines. They can sue Chinese airlines. They could sue Qatari airlines. They could sue any.
Mr. Lobel, if I might redirect you to the question.
Okay, I'm sorry.
Yeah. Why would Congress have put that toggle switch in, giving the president the opportunity to turn on and off liability, if it weren't concerned that there would be Charming Betsy, international law, possible concerns? And it was essentially saying, isn't it kind of an acknowledgement we're not doing the FSIA, we're kind of doing the old regime, the ancient regime, where the State Department tells us whether or not a suit should proceed?
Two responses. One is they were worried about private suits going on, suits against not instrumentalities, but private parties all around the world.
I take that point.
And that's why they wanted the president to have the right not to suspend the FSIA, but to suspend the cause of action generally. They didn't say you can suspend the cause of action against foreign instrumentalities, or they said you can suspend the cause of action because the cause of action itself was very controversial. And second, they didn't want the president to toggle on and off on immunity. They just said the president can suspend the cause of action. But they didn't say anything about whether the president could override immunity.
The effect is the same. I mean,